Today, we're looking at a case that sits at the intersection of privacy, technology, and law enforcement. A story that raises important questions about the limits of government searches and the use of privacy-focused technology. It centers on Sam Tunick, a U.S. citizen charged after his phone, running an alternative operating system called GrapheneOS, wiped itself during an airport search in Atlanta. Why should you care? Because this case could influence how privacy tools are viewed legally and how your digital rights are protected or challenged at the border. So what exactly happened? Tunick was returning from a trip abroad when he was stopped at Hartsfield-Jackson Atlanta International Airport. Federal agents questioned him, citing suspicions tied to his alleged involvement with protests against a police training facility known as Cop City. The agents repeatedly asked him to unlock his phone. When Tunick eventually entered his passcode, the phone appeared to reboot and wipe its data. That phone ran GrapheneOS, an open-source operating system designed specifically to enhance user privacy and security, including a feature that allows users to erase their device quickly with a passcode. The government argues that Tunick intentionally destroyed evidence by triggering the wipe, charging him under a federal law that criminalizes destroying property to prevent seizure. The defense counters that the search violated his constitutional rights, pointing to repeated denied requests for a lawyer, no warrant presented, and no reading of rights, and that the data loss was a consequence of the phone's built-in security features, not a criminal act. This case is notable for potentially being the first time a U.S. federal statute targeting destruction of property is applied in the context of an operating system's security feature. Experts warn this could set a precedent where using privacy tools like GrapheneOS might be seen as suspicious or even criminal by default, which raises concerns for anyone who values digital privacy. In the short term, we can expect heightened scrutiny by law enforcement at borders and airports, especially toward travelers using advanced privacy technology. This could lead to more confrontations, legal battles, and possibly demands to weaken or bypass such security features. The case also spotlights ongoing tensions over protest movements and how technology intersects with law enforcement efforts, especially when federal authorities step in after state-level charges falter. Looking further ahead, this case may shape how privacy-focused operating systems are treated under the law. As courts side with the government, we might see increased pressure on developers to build in backdoors or weaken privacy protections, which would have broad implications for user security worldwide. A defense victory could reinforce the legitimacy of privacy tools and affirm constitutional protections against unreasonable searches and seizures, even at borders. Beyond the legal realm, this story underscores a growing challenge. How do we balance individual privacy rights with government security interests in an era where our phones hold vast amounts of personal information? For everyday users, it's a reminder that the tools designed to protect our data may also attract legal scrutiny, especially in sensitive contexts like international travel. To wrap up, this case involving Sam Tunick and GrapheneOS is more than just a courtroom drama. It's a bellwether for the future of digital privacy and civil liberties. It highlights the complex dance between technology, law enforcement, and constitutional rights, a dance that will only become more intricate as our devices become more secure and our data more valuable. Staying informed about these developments is crucial, as they affect not just a single individual, but the broader landscape of privacy and freedom in the digital age.